Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkar. In this video, we are going to discuss the topic of delivery of the judgment. Previously, when the ink pens were there, when the judges complete the writing and signing of the judgment. Of course, writing was not there. Presently, they have gone for typing. Now it is computerized. After signing, they used to throw out the pen after signing. So, pali nalakottesi pen itla virichesi paresevaru. The reason is that they will not interfere in the judgment. They will not alter the judgment. They will not do anything with the judgment. That is the situation. But here, a typical situation has come where the judgment was delivered in the open court, but after 16 days, it was signed by the judge, that too after his transfer, whether this judgment is valid or not. Simply to say, if there are no changes, it is valid. Now we will discuss the case in detail. So, Justice Sharmila Deshmukh of Bombay High Court in Suvarna Ratnakar Taras. This is a very loaded case. Suvarna Ratnakar Taras versus Mangal Prabhat Lodha. Mangal Prabhat Lodha in WP number 737535 by 2023 on 17th July 2023. Held that, please remember, the Bombay High Court held that if there are no changes in the judgment, even though it is signed later, doesn't make any difference and the judgment is not invalid. Why this problem has come? Because the other side, the defendants, here we can say that they are the respondents. They went to the High Court. Ultimately, the matter was settled now. To go into the facts of the case, please remember, in 2019, Suvarna Taras or Suvarna Ratnakar Taras, she is the appellate now. So, she actually filed a petition in OS number 237 by 2019 seeking the relief. The relief is partition and possession of her share. Partition and possession of her share in 4 properties in Pune. This is one relief. You all know, according to explanation 4, that is constructive res judicata also of section 11 of the CPC, I told you that whatever offense, whatever defenses you have got, whatever offenses you want to attack, you must put them in only one petition, only one case. Of course, if the matter to be directly and substantially the same. So likewise, she asked for the share of the properties and possession of the same. And she also requested for a declaration suit stating that 5 sale deeds which her father and brothers have actually transferred in favor of the respondents, that is Lodha, Mangal Pratap Lodha, they may be declared that they are not binding on her. Very simple, because she has all been married and she is saying separately. She wanted a partition at the same time regarding other parties, other properties. She doesn't want to bear the responsibility. Right? The trial court, please remember, the trial court partly allowed her petition because a lot of litigation is there. And actually directed the respondents to maintain the status quo. Against the status quo, respondent numbers 18 and 19, that is Mangal Pratap, Lodha and others. Lodha, they are very famous builders. So they went to the court, they filed an appeal, that is civil miscellaneous appeal, stating that they should not be actually ordered to maintain the status quo, but they are not covered like that they have to. So ultimately what happened is, the order of status quo was set aside to particular extent of 6,800 meters. 6,800 meters. Right? Then judge passed this order. Judge passed this order on 23rd February 2023 in the open court, that he has modified the status quo. Only the status quo will not apply to 6,800 meters like that. He has given the open court, he has given the judgment, but it was not signed. It was signed on 16/3/2023 when he was transferred. This was known too. Even the website also clearly says that, of course, the website says that he has signed on 27/3/2023 and it was uploaded on 29/3/2000. That means there is some delay. We have to accept it. But when the others came to the court and stated that the judgment was signed lately, at that time he was not the judge, another person has taken charge, therefore this judgment signed by the so-called judge is invalid. But it was held not to be correct because of the administrative reasons. He may be busy, he might not have signed, but he has delivered it in the open court. There are no deviations from the judgment. So therefore, it is a valid judgment based on so many cases. But anyway, it is a very good caution that the judge cannot sign on a later date. People will be observing you. Your own people will tell the others. Don't be under the wrong impression that nobody will see me. Your own people will be telling the others, and this is the situation. Should not have been the situation. When you deliver the judgment, you should have signed on it. What is the problem? You should have made ready. You give the dictation, that man is there, ask him to produce. Or you postpone the judgment to a couple of days till it is ready, computerized. So this problem would not have come. Anyway, there is a lapse. It should be rectified by the judiciary. Right? Luckily, it was allowed to be a valid judgment. But if the High Court says no, since it is signed, because on that day you are not the judge, on that day some other judge is there, then how can you accept it? If they take in that direction, it will be very, very painful to the judge who has delivered the judgment. This is a precautionary principle, right? Anyway, to conclude, as far as our part is concerned, please remember, even though the judgment is pronounced on some date and it is signed on a later date, it is not becoming an invalid judgment. If you know this much, it is sufficient. Thank you.